The opposition has presented their testimony. The appellant will have a period for rebuttal. The board in their rules provides the appellant in cases without opposition 5 minutes for the appellant to present their case. In a contested case, the board provides 10 minutes for each side to present their testimony. Should an appellant wish to provide rebuttal testimony, the appellant should reserve some of their allotted 10 minutes for the rebuttal. The Metro Code requires that these proceedings are taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted, if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through all cases set for public hearing today. After each case, the board will discuss and vote on that case. The board is vested with the power to act on these cases before us today under the following provisions as outlined in the Metro Code section 6.28.035. The code requires 4 members of the 7-member board present to constitute a quorum. The code also requires 4 affirmative votes to grant your application. In the event that there are only 4 members present and there are not 4 affirmative votes, the cases will be rescheduled for the next available public hearing cycle. In the event there are 5 or more members present, which hopefully perhaps later today, but the case, and there are not 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. The appellant and any aggrieved property owner may request rehearing within 60 days of the public hearing. Further, the appellant or any aggrieved property owner may also appeal the board's decision to Chancery Court within that same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that a permit must be obtained within 2 years for the board approval to remain valid. I submit that all cases have been filed in proper order. All appellants have been notified by certified mail as required by the code. All affected property owners have been notified and the legal ad has been published in the Tennessean as required by the code. At this time, we'll recognize any elected officials that wish to address the board. Seeing none, I want to announce that the cases that have been withdrawn or deferred, in case there's anyone here in opposition, these cases will not be heard before the board today. Case 2022-22 was withdrawn. That's 119 Chester Avenue. Case 2022-24 was withdrawn, 2821 Raider Ridge. Case 2022-26, 806 Vibe Place was deferred until the next meeting. Anyone here in opposition to any of those cases? Seeing none. The first case on the docket is 2022-018. That is 904 A, B, C, D Ramsey Street. Is the appellant here for that case? Is there any opposition present? Seeing none, there'll be a 5-minute time period. This permit was denied because it did not have a UNO or a C of O on December 31st, 2021 in a RM20 zone district. The UNO letter is a use and occupancy letter. It's the last step in the building permitting process that allows you to use the newly constructed or renovated home or business. The C of O is a certificate of occupancy. It's a document issued by the building department and Metro Code certifying that the building's compliance with the applicable building codes and other laws and indicating that it to be in a condition suitable for occupancy, usually temporary for a specified period of time, to allow all conditions to be met for the final UNO. This is an RM20 zone district, and this is governed by BL 2020-187. The decision of the board is whether or not the zoning administrator erred in the denial of the permit. Ordinance BL 2019-1633, effective date August 23rd of 2019. Section 1, limited owner-occupied short-term rental properties as commercial use permitted with conditions in the following zone districts. These zone districts exclude all residential zones, including residential multifamily. Section 15 of the ordinance states the provision of Section 1 of the ordinance shall become effective January 1st of 2022. This extended the availability of the not owner-occupied STRP permits in the RM zone districts, including RM20 zone districts, for just over 1 year and 4 months. Ordinance BL 2021-913, effective date November the 3rd of 2021. This ordinance amended BL 2019-1633 by changing Section 15 to read, the provisions of Section 1 of this ordinance shall become effective January 1st, 2022, provided that anyone with an active short-term rental property not owner-occupied permit application on file with the Department of Codes Administration as of December 31st, 2021, shall be eligible for the permit to be issued if all of the conditions are met and if the final use and occupancy letter for the building is issued on or before December 31st, 2021. The main list of permits is as follows. January 17th, 2020, Smith Estates, LLC, obtained 904 ABCD, Ramsey Street. March 20th, 2020, permit application filed for demolition due to storm damage caused by the tornado. March 20th, 2020, 904 E, Ramsey Street, Common Space, OIC, that's Ownership in Common, CAUO Building, Use and Occupancy Master Permit initiated. March 20, 2020, plans reviews and approvals process started. March 20th, COVID-19 closures hit, and as well as the interruptions caused by that. On March 3rd of 2021, the plans reviews and approvals process was completed. The master permit was issued. On March 21st of 2021, the permit application filed for sewer tap and cap. On April 12th, 2021, sewer permit issued. January 7th, 2021, commercial building progress inspection. The inspection discovered and communicated to the contractor that the project was not properly permitted. June 22nd, 2021, the permit application was filed for building residential new. On August 31st, 2021, the building permit was issued, and master and 4 separate unit permits under the master. This is the way the permit should have been issued initially. The contractor realized this and asked for a clarification from the zoning department, which will be explained later. November 24th, 2021, the CARP building residential change of contractor. December 31st of 2021, the STRP permit application was submitted. The following is the list of pertinent emails. I have only emails that I was able to collect, and I do not believe that I have all the emails exchanged concerning construction permits. But on February the 17th of 2021, the contractor for the building project, Daniel Owen of ORCA Building Group, LLC, expressed concerns that a single building permit was issued as opposed to a master and 4 unit permits with respect to the January 1st, 2022 STRP permit deadline. February 22nd of 2021, email from Mr. Owen to the zoning department requesting clarification. The response that was received was, if the units are going to be individually owned with separate deeds, you will need individual permits. If the units will be under one ownership, you can use one permit. Construction began, I'm unsure of the date, probably around May of 2021. June 14th of 2021, according to emails from Mr. Owen to the zoning department, the first inspection had taken place, and Mr. Owen was informed by the inspector that it was not properly permitted and further inspections could not occur until the property was properly permitted. The zoning examiner forwarded the permit to the zoning administrator for review. July 2nd of 2021, Mr. Owen again emailed the zoning examiner to see if the permit review was complete. The zoning examiner responded that 4 permits had been initiated, 1 for each of the dwelling units. The permits were not ready to be issued as the review approval was not complete. The review approval should be expedited since the original permits had undergone the review and approval process already. June the 9th, 2021, Mr. Owen again emailed the zoning examiner to see if the permit review was complete, and the email gives no indication, but it seems the permits were issued. Mr. Owen again, on July the 19th of 2021, Mr. Owen again emailed the zoning department as he was still having problems with the inspection sign-offs because there was no master permit. The zoning administrator changed the original building permit to a master permit. To summarize, there were delays caused by improper permitting and COVID-19. Initially, a single permit was issued instead of the project master with 4 individual unit permits under the master permit. However, the zoning administrator had no way to determine how much of the delay was caused by the improper construction permitting. Due to the STRP application being submitted after the effective date of BL 2021-913, the zoning administrator was bound to deny the permit. In retrospect, if the STRP permit application had been submitted prior to the effective date of BL 2021-913, November the 3rd of 2021, we might have been able to legally issue the permit when the final UNO was issued. Mr. Smith also incorporated a solicitation on the short-term rental appeal neighborhood notification letter, which is on Metro's letterhead, about which we received several complaints, but Mr. Smith was certainly made aware of that. 7 letters of opposition were received at the time of the writing of this case summary, and I believe additional have been received. They will be in your board packet. And that concludes the city's presentation.
Very good. Any questions for Metro before we hear from the appellant? And obviously, Mr. Loyko is going to sit this one out just because, isn't that correct? Because he's come in halfway through the reading? Is that correct? That's correct. Okay, very good. Any questions?
I have a question for staff. Has the UNO been issued on this property yet?
At the time of the writing of the summary of this case, which was within the last 10 days, it had not been issued.
Okay, thanks.
Any other questions? Okay. Mr. Smith, there is is that correct? Leland Smith, yes, is that right? Very good. There is a button on the microphone in front of you. If you could press it once so that you see that the red light illuminates, great. You're going to speak into the microphone, give us your name and your address where you live, not the address of the property, and you'll have 5 minutes. Is that correct? 5 or 10? 5. 5 minutes to share with us your situation. And we're going to be very cognizant of the time today, just with the length of the agenda.
Okay.
Okay?
When does it start? Right now.
Please, go right ahead.
My name is Leland Smith, a resident of 4902 Inglewood Court in Nashville. Good afternoon, ladies and gentlemen of the board. Appreciate your time hearing my request today. I'm a resident in Inglewood, East Nashville, where I own a property that I rehabbed in 2018, started short-term renting in 2020 while away on business travels. I enjoyed using my home, meeting many new travelers, and after that rehab project, I was interested in building new development as I liked architecture process. And December 2019, I found 904 Ramsey property. Just sits off of Smith & Len's Brewery on the back of Main Street commercial businesses. As with many of the lots in the neighborhood, they're taking advantage of the increasing tourism that was advertised for short-term zoning and marked up significantly for that purpose. I had the same goal to use the parcel to its highest best use, I felt, and build 4 units that could short-term rent while managing nearby. I specifically designed the architecture to maximize this use case. In fact, within that Ramsey and 9th Street to Myrtle block, just north of Main Street, non-owner occupied properties represent about 90% of the parcels I estimated. The neighborhood makeup is almost entirely investor-owned properties. I'm here today to request variance to the recent legislation requiring the UNO for short-term rental application by December 31st, 2021, which I had submitted my application on. On this property, I had begun permitting on March 2020, as you'd seen there, on the basis that Metro codes had prevented me from completing the project by taking a reasonably, unusually long time to approve the initial building plans prior to starting, and then after starting the build had incorrectly permitted the parcel, subsequently with the inspector denying inspections until Master Codes had reissued the permit. I'm not certain as to why it took from March to October 2020 to approve the original plans, as they were straightforward townhomes that had apparently previously gone through the process for similar property on 9th Street. But also, as you heard, they were had a COVID slowdown and the city's expansion. With the COVID slowdown, my GC explained he could not see anyone in person and had to wait on emails. And that shows, that record that I had submitted shows about 5 to 6 months of unaccounted for time and delays in that process. Once the permits were issued in November 2020, the HPR for what I called the Leland for my HOA was filed in January 2021, and in February we started the project. The contractor, as you've seen, pointed out to Metro that the permit had a single master versus 4 parcels, which the HPR called for. Morgan Walter from Metro assured that since it was a single owner for, he also had pointed out that I exclaimed that I was going to own them all and use them as for short-term rental purposes. Morgan Walter exclaimed that since it was a single owner for all 4 parcels, the permitting was acceptable. But then in June, as you saw, that the inspector refused to inspect until all 4 permits were in for each parcel. So they restarted the permitting process, which didn't complete until August 31st, which was another 3 months after that initial realization. Since there were no individual parcels after nearly 7 months after the initial permitting, it caused a waterfall of delays in progressing with long lead items such as electrical hookups, sewer, water taps, which couldn't even be requested without the individual permits. Utility hookups would have started when the block foundation and framing was done normally. NES, for example, had a 3-month backlog of projects and couldn't even provide an electrical design until January of this year. In fact, they only hooked up the electric in early May of this year, and only then can I start the trim outs. Normally this would have been done much earlier, as there's all the other steps and grading of the property and so forth. Skip some things here. So in the summary here, I feel that my property permits were unfairly handled compared to other nearby properties, such as an 8-unit complex and the neighboring HPR on Ramsey, which had its approvals within 2 months and are now operating short-term rentals. It would be a difficult process for me to change out the HOA documents, split off one of the units for myself, which I probably would want to do to owner-occupy short-term rent to make up for the extra expenses. In the case that I were to sell the units, since they're split level, I feel like they would be well advertised as owner-occupied STRs, as that's a high-demand feature of that area. And so of all the potential property uses, I don't feel the board's decision would make a predictable or perceivable change in the neighborhood's dynamic or more or less neighborly satisfaction in any direction. So I would ask that the board consider a variance to grant extension for myself, the owner, to permit the use of NOSTRs, the original owner since January 2020, so that I may own and operate these to what I believe would be their highest best use to all stakeholders, including the neighborhood and the city. The variance, of course, would only allow myself, the current owner, to proceed with the STR application submitted on December 31st, 2021. I thank you for your consideration of the matter, and I hope for a fair and gracious decision. I did want to point out a question I saw on the notice that said something about if I had submitted prior to November 3, 2021. I wasn't sure that I thought the date for that extension, or the date was the December 31st, 2021. I'm
afraid your time is up.
Okay.
That's what that signifies, yes? That was time? Yeah, okay. And we can discuss that in the Q&A portion here. I think we're talking about, I think that remark reflects had you applied at a different time or had the application come in at a different time, it would have been we deal with this every case. There are different ordinances that govern different applications depending on when they were made. So I think that's simply pointing out that had it fallen at a different time, it would have fallen under a different ordinance, and that's just not the case based on when it was made. And it wouldn't have been necessarily changing your outcome. Who has questions for Mr. Smith?
Thanks for being here, Mr. Smith. I heard your statement just now, and it seems, other projects in the neighborhood were moving along, on a closer to regular time span, even through COVID. You said that you believe that your case was treated unfairly. I guess I'm trying to understand, because when I read all these emails between you and various staffers within Metro, I'm seeing staffers really making an effort, going out of their way to work with you and try to find things. I mean, I think the life safety folks at Fire at one point said, I really am not crazy about this approach, but we're gonna make it work here, and in the future, we're not gonna do this again. So, I mean, I guess, you know, I'm just trying to understand more about why this is, other projects are moving along, and you feel like yours was just somehow singled out or treated unfairly.
I don't have specific evidence except for the facts that it was taking longer than other folks. But in the fire marshal example, what I understand is that the architect had approved from a fire marshal. That fire marshal had retired in the middle of that approval, and a new person was onboarded. In fact, in the record, you can see that he said he didn't even access to the system yet, and he was trying to get access. And so I think maybe the new person, what I understand, where they're trying to find new of ways to implement the IRC code. And so it was kind of a lot of back and forth between the architect and codes that I wasn't involved in, because, you know, I was just paying the GC and those guys to handle all this stuff. And eventually, after a couple of months asking him where it was, that's when I emailed him, which I copied in the packet there, the email conversation, and, was asking what the situation was. So, yeah, I had called a meeting, and yeah, they were nice and everything, and I don't blame any person in codes or anything, but it just took a while to discover what would be acceptable, and so it was like they didn't really have a handle. I talked with other developers that were developing in the same neighborhood, and they said, oh, yeah, they made us put on this thing, this garden thing. And I said, I suggested the same thing, but, so it just seemed like the kind of the standards were evolving and changing in a couple of cases that I have. And like a later example I had, like when the foam insulation was in, the building inspector, he had inspected several times. And then on the fourth time, he came back after I had put in all the roll-in the ceiling. He said, oh, no, you have to foam the ceiling because it's not vented or something. I said, well, how come you didn't notice that the first time? So they had to pull all the insulation down and redo it and everything.
Sure. Okay, thank you. And at what point did you become aware of the passage of 2019-1633, the bill that, or just the existence of that rule that, non-owner occupied permits would no longer be allowed in residential areas, including RM? When did you become aware of that?
I was aware of that when I purchased the property. I looked into it and said, hey, what is the date? Said, originally they said January 1st, 2022. I said, okay, fine. I have 2 years to talk to the builder. No problem. We do builds in 6-8 months. But obviously, COVID changed all that. And then sounds like some of the churn on the board changed that with the fire marshal changes. And then the mix-up of the incorrect permitting in the beginning for, I don't know why that happened, but, and I went back and forth with Bill Herbert and met with him in October of last year and asked him, how can we change this? Can I change the zoning to a condo or something? And so I tried to find any way that I could to get it to be zoned in a way that it could work for me. But that was, I think, one of the major hangups that caused it to not finish, honestly, because they just sat on, couldn't do rough-ins until September.
Okay.
And they had to re-pull the permits, yeah.
Okay, so you'd agree that you purchased the property with the risk of time sort of not being on your side and the potential that you would end up in exactly the situation that you're in now?
There was that risk that,
Right.
I had 2 years, and so but I had no expectation that something would take that long.
Sure.
This was my first build that I've ever done, by the way, so.
So, Mr. Smith, we have heard from quite a few of your neighbors. We normally get 1 or 2. We've gotten 9 requests that were not in support of your project or your request, including one that came via the district attorney's office, which is novel. And that's due to the fact that when you sent out these notices to your neighbors, you added, P.S., if you're ever interested in selling any property in the area, please contact me and your phone number on the appeals letter that you were required to send out. And I think that may be what garnered so much attention for you.
Oh, probably. That's what I learned. Yeah, Joey Hargis called me and said that wasn't the right thing to do. This was when they requested I send the letters. I figured it was the same thing as the short-term permit. I write up a letter and send it out to the neighbors. I'd never done a zoning change, so I barely looked at the thing. I had to figure out how to send out 266 letters. It was, like $500 or something. I figured I'd at least put my contact information. Killed two birds with one stone. So I just hired a company that does this mass mailing thing. I said, hey, just put on a thing on there or whatever. But I felt kind of weird. I glanced at it and I was like, oh, this is weird. It's like Metro letter. I don't know why they would have me send out a letter because I'm not Metro, so I can understand why that would be perceived wrongly. But I was just kind of trying to get it out fast. Yeah. I thought it was the same thing as the short term where it was coming from me. I'm the one who's sending the letter. But I guess that.
But how did you were given a copy of this letter or you were emailed a copy of this letter and then you had to share it with this company that you hired, yeah?
Yeah, I just forwarded it and said, yeah. Here,
so you didn't notice that it was Metro letterhead?
No, I did. I looked at it briefly and I thought for a second, it's kind of weird. Why am I sending a Metro letter? I'm not sure. It didn't make sense for me to send something on behalf of Metro. But
we have, as I said, about 9 contacts, including the president of the local neighborhood association. And one of them actually shares with us that despite the address you gave us in Nashville, that you actually live in California.
I work in California, but I have remote work. So yeah, I'm here a lot of the time in that area for work.
And your driver's license is
driver's license is here. Yeah.
In Nashville, and your car's registered here and all that.
Yeah, I intended to establish that as my residence, as I did not want to live in California.
Okay. Anybody else have any questions? Sure.
Yeah, just for the record. So I talked with Mr. Smith about his additions to our letter that we send out. And,
Microphone.
We talked for a good 15 or 20 minutes, I think we did that day. And it's the first time it's ever happened. I've been with Metro 22 years for Board of Zoning Appeals notices. We shifted the burden to the applicants 6-8 years ago at the BZA. So we started doing that when this board was formed. It's the first time we've had that concern. I did reach out to the district attorney's office to see, is there some violation of code? And there is not. And we've discussed, and I've talked with staff about firming up our outgoing paperwork to appellants that this letter is to be sent as is, make no alterations to it. So to the standpoint the comments come in about his addition to the letter, two things. One, it's not germane to this case, to the heart of this case. So I do ask the members don't give weight to that. The other part of his is living here or not. These are non-owner occupied permits, so we didn't take issue with his ownership. I'll just say, just brief comment on the timeline. There's clear some delay occurred in my office with the permitting of these. The initial setup of the permit's not correct. We would do a master permit and a shell and then finish outs per unit. They did it as one for some reason when I look back through the staff. So as Mac talked about, there was some delay, but I could not put a finger on how much, whether it flipped the balance. In this case, if I felt it was a significant delay, I actually would have issued his permits to him and bypassed this whole thing. But it was a close enough call that I felt that's y'all's decision to make, not mine.
The letters that we have, I don't think any of the letters specifically mention the solicitation on the alert. I'm just taken aback by how many there are because we don't normally.
There were quite a few.
Quite a few compared to what we normally.
I was contacted by media outlets here about a couple of local news media wanted to discuss it. So I just didn't want that to veer off.
Sure.
Right. And I thank you for pointing that out. I do agree that those issues are not germane. I don't think that there is much. I don't think there's much evidence either to indicate that the administrator erred. So.
Right.
Well, if I may remind, we still have the public hearing open.
We have the public hearing
We've been
open,
joined by some more folks. I do want to check to see that if any folks are here to talk about Ramsey, you will have the opportunity to do so in a moment.
Yeah. And do we need Mr. Hargis to introduce himself for the record, since he just...
Happy to. Joey Hargis, Metro Zoning Administrator.
Very good. Any other questions? Okay, we're going to consider the public hearing closed. If we
Nope.
Sorry?
There might be members of the public here.
Oh, I didn't see anyone raise their hands. Has anyone appeared? Oh, very good, back there, okay. So, why don't you come forward?
Am I able to make any comment on the letters that you were talking about, the 9 letters?
We don't have any question before you right now.
Okay.
Come have a seat.
Hi there.
Hi. So we
We have 10 minutes for the opposition, and then since Mr. Smith used his allotted 5 minutes, he'll have 5 minutes for rebuttal.
okay. Very good. If you would be so kind as to give us your name and your address, and then share with us your remarks.
My name is Wade Barnes, and I own 115 North 9th Street in Nashville. It's close by Mr. Smith's property.
Great.
So I'm just in favor. I realize you got 9 letters that said that they're opposed, but I think it's in line with the heart of that community to have short-term rental. So I'm just in favor. I wanted to voice that. So I don't have anything to offer beyond that, but
Okay.
I don't think there's any reason not to do it. I think that, Mr. Smith is going to live there, whether it's, half the year or the majority of the time, but, he'll take care of it, I believe, and I think it would help that neighborhood. It's a great property. It's a great structure, and I think that it would be a helpful thing for the neighborhood.
Very good.
Since this was support, not opposition, then Mr. Smith will not have any time for rebuttal.
Very good. Okay. Thanks so much for your
Okay.
time.
Yep.
Okay. Shall we consider the public hearing closed? Are you speaking in favor?
It's an absolutely gorgeous building.
Could you wait until we find out whether or not you can speak in favor before you speak in favor?
The 5 minutes for Mr. Smith the allotted time has expired.
Okay, very good. We're going to consider the public hearing closed.
And that does include anyone that is in support, so that 5 minutes total.
Great. Okay. So we're going to consider the public hearing closed. If we reopen the public hearing and have any further questions for you, that will be another opportunity to speak. If not, we're going to consider the public hearing closed and we won't hear from you again, okay, Mr. Smith? So we can discuss this amongst ourselves and decide how to proceed. And I think, Sean, back me up, this is very limited. The question before us is, did the zoning administrator err?
That is, I think, the scope of this question. And, if I can speak just a little bit to the bill that sort of phased out RM in residential zoning, or I'm sorry, phased out non-owner occupied permits in RM zoning, which was the last residential zonings that still allowed non-owner occupied. That was passed at the end of last term, so at the end, summer of 2019. I was not on the council at that point, but, I had a lot of discussions with neighbors about that bill, and with council members as well when it was being proposed. And, I can speak to the sentiment of this neighborhood, which is an RM zoned neighborhood, was deeply, deeply supportive of that change. Folks, saw the existence of non-owner occupied permits in RM to begin with as something of a loophole. That's the way it was widely discussed and talked about. Just because it's attached multifamily product doesn't mean that, it's somehow different from other residential, was the sense in the community. So, there was broad support for this change in that neighborhood. And, the bill was ultimately amended to stretch the date out. Advocates, which is the category I fell into at the time, were looking for 6 months, 9 months, sort of a typical timeline, so that anybody that had sort of, vested and started a project would have time to finish that project and then be able to get a permit. The deadline was extended to 2.5 years. That was widely regarded in the industry, the short-term rental builder industry, as a win for them. It was considered extraordinarily generous. And I think that on a precedent and on a legislative intent angle, we made this small change with 2021-913 to sort of nudge that window open and give folks some certainty who are working in that space. I think that I'm personally very wary of setting a precedent where we're using this process to even nudge that further after what I consider was a very generous target, and then this sort of cleanup extension thing that we did with 913. So that's just a little bit about the, this is in my district, so the letters of opposition, you highlighted that the neighborhood leader was one of the folks that wrote that. We've got lots of folks in the area as well. Additionally, there were 3 people that showed up at the last meeting
That's
who,
right. You're absolutely right.
did not speak because the case was not heard. So,
Precisely.
and I can't speak for those people, but I do know those people, and I can guess what they were going to say.
Well, they all identified themselves as being there in opposition, so
Yes.
I had
So-
forgotten about that. That's a very good point.
And I don't believe any of those 3 submitted letters,
Okay.
unfortunately. So that's just a little bit about my take on the neighborhood feel and the legislative intent and sort of where we're at with this request and requests of this nature. So
Okay.
I do want to make clear again, though, just so that our decision isn't later attacked as arbitrary or capricious, we're not, in making our decision, vindicating the concerns of those particular people. It's not pertinent in this case how they feel about this particular these particular permits being issued to this particular person. So I just want to make that clear on the record. We're simply deciding whether or not the zoning administrator erred, and I think it's a fairly clear-cut case. The cutoff was December 31st. The construction wasn't complete. The permits weren't issued. So I would make a motion that the zoning administrator did not err and the request for relief is denied.
I would second that motion. Ron, did you have anything you wanted to share or discuss before we proceed?
I'm fine.
Okay. So the motion has been seconded. Can I see a show of hands? The motion is we agree with the zoning administrator's decision and we do not believe that he erred in this case. Can I see a show
all
of
those
hands?
in favor?
All those in favor? Okay, the motion carries. So there won't be any relief granted in this case, Mr. Smith, but thanks for coming and we appreciate your time. All right. Which one's next?
The next case
Yeah,
before the
seriously,
board
all those emails.
is case STR 2022-021, and this is for 1917 A and B Herman Street and 1934 and 1936 Britt Place. The not owner occupied permit for this property was denied because it did not have a UNO or a C of O on December 31st, 2021, when they're in a RM20 zone district. Very similar to the last case, the RM20 zone district governed by 2020-187. As previously described, the UNO letter and the C of O certificate of occupancy were defined. The ordinance bill 2019-1633, effective date 8/23/2019, Section 1, limited not owner occupied STR permits as commercial use permitted with conditions to the following zone districts, which excludes all residential zones, including residential multifamily. Section 15 of the ordinance states that the provisions of Section 1 of the ordinance shall become effective January 1st, 2022. This extended the availability of the not owner occupied STRP permits in the RM zone districts, including the RM20 zone district, for just over a year and 4 months. Ordinance BL 2021-913, effective date November 3rd, 2021. This ordinance amended BL 2019-1633 by changing Section 15 to read the provisions of Section 1 of this ordinance shall become effective January 1st, 2022, provided that anyone with an active short-term rental property not owner-occupied permit application on file with the Department of Codes Administration as of December 31st, 2021 shall be eligible for that permit to be issued if all of the conditions are met and if the final use and occupancy letter for the building is issued on or before December 31st, 2021. The following is a summary of the email chains submitted for the board packet by the appellant. January 27th, 28th, 2021, Maurice Perry and Newman Designs and the zoning examiner Clint Harper exchanged emails about the project design, the questions for the project design. On March 25th of 2021, Barry Greer of RK Junior Development Group, LLC, submitted plans and documents to Clint Harper for review. Barry Greer on April 5th of 2021, Barry Greer and Clint Harper exchanged emails regarding required setbacks. On April 13th and 14th of 2021, Barry Greer and Clint Harper exchanged emails again. The master permit for the construction was initiated, and there would follow 4 child permits under the master permit, one for each of the 4 units in this appeal. Construction permits must undergo a lengthy review and approval process for the plans for the project. Please refer to the permit status report below included in this packet. And see the list of reviews and approvals and inspections and the corresponding timeline. There are 4 units. The 4 units are a horizontal property regime. 1917E Herman Street is the IOC or OIC, and that's its ownership in common. The common ownership for the 4 units in the HPR, which is akin to a mini HOA. Therefore, the master permit is issued under that address. Theoretically, each unit could have a separate owner, so the area of the parcels that do not have a structure on them, open land or lawn, have ownership in common between the 4 unit owners. This is the reason that for the HOA. In this case, however, these 4 units have the same owner. On August the 13th of 2021, the master building permit was issued for 1917E Herman Street, OIC, ownership in common. On August the 16th of 2021, the 4 individual building permits were issued. The properties applied for not owner-occupied STRP permits on 12/21/21, but had no UNO final letters. As of this writing of 5/18/22, there were inspections and approvals yet to be completed, and there are no UNO final letters. 1917A Herman Street, UNO letter denied 3/28/22. And 4/21/22, there was an attached master that needs grading, urban forestry, life safety, sidewalks. On 1917A, on 1917B, it was the same requirements yet to be met. On 1934 Britt Place, 4/21/22, UNO letter denied, need grading, forestry, life safety, and sidewalks. And same date, 4/21/22, the same requirements for 1936 Britt Place remain to be met.
Okay. Any questions for staff before we hear from the appellant? All right. Very good. If you could introduce yourself for the record, your address, and if more than one individual is going to be speaking, the time has to be shared amongst you. Is there anyone here in opposition to this case? Go right ahead.
Okay, is this for 21st Avenue North or off of 21st and Herman?
This is for 1917 A and B Herman Street and 1934 and 1936 Britt Place.
I'm just talking about, they haven't talked about the 21st on the corner part of 21st and Herman.
I don't know how to answer that. Are you asking, is that a property at the corner of 21st and Herman?
See what I'm saying, they already got a market there, and no one has sent no letter out yet if they gonna build a house or a skyscraper apartment. And I just want to know what's going on.
Okay. I don't believe we're talking about the same spot.
Right.
I don't believe we're following the rules at all about how we're supposed to be handling this.
Whether there's opposition present impacts how much time they get.
Yeah. So So is there opposition to this actual case, 1917 A and B Herman Street?
I see a hand.
1934.
I see a
Very
hand.
good. Okay. So there is opposition. So we're going to have, remind me, 10 minutes for the hearing of the case, 5 minutes for the opposition to, or 10 minutes for the opposition to speak, and then another 5 minutes for the appellant to rebut what is heard.
No, there will be 10 minutes allotted for each, for the appellant and for the opposition. If the appellant wishes to rebut the opposition, then they need to reserve a portion of their 10 minutes for that rebuttal.
Thank you. Thank you, thank you. Okay, so I'm sure learned counsel knows all this much better than me, so you can, account for your time accordingly.
Madam Chair, thank you. Sean Henry, 500 11th Avenue North. I represent Mr. Kelly, the owner of the subject property. We would like to reserve 2 minutes for rebuttal. Appreciate that. Just quickly, I just want to make a couple of general statements about the agenda. I'm going to turn it over to Mr. Kelly to tell you about the facts. The agenda has on there that this board has no discretion, it looks like. It says discretion, no. I completely disagree with that, and I want to just emphasize that this appeals board is a quasi-judicial board. Appeals from your decisions go to Chancery Court. Chancery Court is a court of equity. So equitable principles, equitable issues, fundamental fairness, those kinds of elements absolutely are appropriate for you to consider and can guide you in your decision making. Those are the legal standards that I just want to point out. And importantly, the application, the title of what Mr. Kelly was asked to sign by the Codes Department is entitled Applications for Interpretation Against the Zoning Administrator. It's an interpretation. So you're making an interpretation here today based on the facts that you see and hear and the law that we're going to cite here in a few moments. So I'm going to turn it over to Mr. Kelly. Thank you.
My name is Ronnie Kelly, owner of Arcade Junior Contracting Services.
Mr. Kelly, sir, your address, please.
Oh, I'm sorry. We're now located at 327 Springs Way, Suite 250, Brentwood, Tennessee, 37027.
Okay, is that your work address or your home?
It's our office address.
I think the requirement is your home address, yeah, in the record? No? Nope, okay, I guess we're happy with that. Sounds good, go right ahead.
Yes, it's the representative spoke initially. A lot of what we had in the prior memo, I guess you would call it, is what we're here to discuss, obviously. We purchased this property January, February of 2022. Yes, I was aware that the RM zoning was being taken away for short-term rental permit consideration. I was well aware of that. I was actually, I've known about it for the 2.5 years, as you all has mentioned as well. The reason for for me moving forward with actually developing the property and still pursuing the STRP permits is because from my experience as a builder in the Nashville market, I could build a house in 6 to 8 months. And this was obviously not the case. And a lot of my emails that we're showing you, even up until now, May 2022, we're still not getting the proper cooperation from Metro, if you would call it. Right now, we're still trying to get a UNO, and we're waiting on Stormwater to approve that for us to further our process to get the UNO. We haven't heard back from them in over a month. We've tried contacting them numerous times, and I'm not here today to try to go against the grain or do anything I feel is not necessary in my case. I really think I should be considered and allowed to continue to finish the project and honor the STRP in any way the board may find appropriate. But outside of that, I don't have a whole lot to criticize or try to throw something at the wall and see what sticks. I'm just here to ask to be treated fairly. We've provided a lot of evidence showing that we've tried to work with Metro. We've moved as fast as we could. I do have a history of building in this city, and again, I would have moved forward with trying to develop these properties if I couldn't have done it in the right amount of time. So being permitted in August 2021 and having a deadline of December 31st, January 1st, Obviously, my back was up against the wall, and we provided evidence of why we didn't get permitted into August, and it was no fault of mine or my staff.
Could I just clarify the purchase date? Because I believe you misspoke. I think you said 2022.
It's January, February 2021, I'm sorry.
Okay, perfect.
And if I may relate the timeline of the seeking of the permits and the dealing with the codes department relative to the changes in the legislation, we've talked about the 2019 bill that passed, which was intended to permit certain individuals with active permits on file with the Department of Codes Administration as of January 1, 2022, to be eligible for short-term rental property non-owner occupied permits. So that bill passed. Mr. Kelly's moving forward, submitting his drawings, applying for his building permit, gets hung up in the month of March and April, comes out in August with his building permit, immediately starts construction, and then in September, the bill 2021-913 is introduced, and that bill, up until October 19, which was the second reading of that bill in council, that bill said that any applicant who files an application with the Department of Codes Administration prior to the restriction going into effect should remain eligible for their permit, provided all other permit conditions are met. So what that meant was, until the amendment, which is really the heart of the issue here, what that meant was, so long as you got your application in the door, which they did.
Mr. Henry, this will reserve you 2 minutes at this point.
Are we at 8 minutes already?
Yes.
I'll just make this point. So he was absolutely in the clear until October 19, when an amendment was passed, and the amendment said, it changed that language to say, if the final U&O letter for the building is issued on or before December 31st. And obviously, he couldn't get that by then. So this ordinance, this amendment to that ordinance, penalized him because he was under construction. He was under construction, and it penalized him. It had no effect on anyone that already had an existing house, and they just wanted to get a short-term rental permit. So anyone in the throes of construction were severely penalized, as Mr. Kelly was, by that amendment. And we think that's an equitable issue that is fair and right for you to consider. So we'll reserve time for rebuttal, or remaining time, if you will. Thank you.
Very good. You'll have about 1 minute and 10 seconds to rebut.
Thank you.
So could we have the gentleman that's here in opposition come forward? Thanks, gentlemen. Hi. Just to confirm, you're here in opposition, yeah? Okay, because otherwise timing is not going to work out. If you'd be so kind as to open that microphone by pressing the button once and give us your name and your address for the record and share with us your concerns.
Yes, my name is Martin Bauer. My address is 762 Saucy Place, Nashville. I'm sorry, what was it?
And then
That's it? Okay, so
off you go.
I have the immediate next door property, which is also a short-term rental. We've had it since 2017 as a short-term rental. And just during his construction period, which has gone well into 2022, he's had numerous trespassing, erected scaffolding on my property. I sent an email with many pictures. I brought many pictures with me of lots of trespassing violations, property damage, things like that. We had some earlier property damage that we had settled outside of the BZA, which he was compliant with. That was good for a while, and then at some point he has sort of continued to trespass. While I had guests in the house, they erected scaffolding in the yard. And stuff like that. So and then I sent an email with all of the different incidences of that. And if those had been if he had even had his permit issued to him, there would have been enough violations of his permit that we would probably be revoking it today instead. So I don't know if I I mean, I can go into each incident in detail, but I don't know if you guys have that email that I'd sent with the photos and things. And I don't even know if it's even really that relevant. It's really,
We appreciate your comments and coming down today. I think that, I think my fellow board members would agree
Yeah.
that we appreciate that you stand in opposition to this, but it's not particularly germane, right, to the
Sure.
matter at hand. Do you understand that?
Sure.
So if you forgive us, we won't take the time to go through pictures
I understand.
about scaffolding. Is that fair? Okay. Thank you so much for your time
Okay.
today. We
All right,
really
thanks.
appreciate it.
I'm going to try to beat the clock here. I want to make a few more points, and you can, Mr. Kelly can answer any questions that maybe have raised by the other speaker. On the legislative history of short-term rental property permits, I want to make this part of the record, if I can. This is the website that contains all of the ordinances that the city has adopted pertaining to short-term rental. Bill 2021-913 is not even listed on here. Okay, so the public has no idea that that bill is out there. Now, maybe now, but it wasn't in April when we printed this material. Secondly, there's an inconsistency in the ordinance. 6.28.030, short-term rental, non-owner occupied. Application, A, STRP permit applications shall be valid for 90 calendar days from the date they were filed. 90 days. He filed his application, I guess it was December 30. He had 90 days in which to act upon that application, irrespective of that amendment that we just spoke about. He was well within his 90 days, and his permit got revoked during that period, or the application got denied during that period. So that should not have occurred. And finally, what I find, just for the record, I want to say that the amendment to 913 didn't amend the code; it amended the prior bill. So I think there's a defect in the legislation, and it's important for the record to get that in. So
We're out of
thank
time,
you.
gents.
Sure.
Thank you. Okay. Thank you. Who has questions for either council or for Mr. Kelly? Terrence, do you have a question?
I didn't, I'm still formulating in my head, so if someone else has a question, they can go for theirs first.
I don't even know where to start. Yeah,
No, actually, there is.
Okay.
There is, again, it's still, the words are still coming together in my mind. Just give me just a second.
Ellie's just going to start the clock on you.
Sounds good. Yeah, keep me honest on time. So I actually do have a question for Mr. Henry. So it's your position that a general provision stating that applications are valid for 90 days is superior to a specific provision saying that as of December 31st or January 1, 2022, permitting for non-owner occupied short-term rental properties will not be allowed in this area. Is that your position?
That is my position. That is my legal interpretation. And when there's ambiguity between what the ordinance was trying to do and the way the code presently reads, the property owner wins that debate.
Okay. So you're saying effectively that 90-day validity provision would require them, irrespective of the fact that he didn't have all the permitting necessary to be in compliance with the code, it would require them to issue that permit over those defects.
It would require them to allow him to continue processing that application for 90 days.
Do you agree that he has to meet all code requirements for issuance of a permit in order to receive a permit?
Absolutely.
So me, what you're saying is what they should have done is held his application in abeyance for 90 days and then denied it.
Unless he had gotten his final UNO within that 90-day period, then he was entitled to receive it.
Do you agree that the ordinance became effective on January 1, 2022, removing the possibility of non-owner occupied permits being issued for that area?
Well, so we're clear on my legal argument.
Sure.
The amendment number one, we think is invalid.
Okay.
And amendment number 1 is the one that said December 31st, you shall have a final UNO.
Mm-hmm.
We think that is a void or voidable amendment because it didn't amend the code. It amended Bill 2019-1633 without any reference to the code in which it applies to.
Okay.
So that leaves us with the original Bill 2021-913 that Metro Council Mayor Cooper signed on November 3rd. And what that says is, as long as you file your application, you remain eligible for the permit, provided all other permit conditions are met.
Okay.
He had plenty of time to meet all other conditions, but he was prevented from doing so.
Gotcha.
Well, in fact, would he have, first of all, he still doesn't have a use and occupancy. So let me finish my point. So would he have met all the other conditions? When you think about the inspections that are required, when you think about the, all of the steps in the STR application, it's May, and as of a few weeks ago, he still doesn't have a UNC.
I'm going to let him answer that question.
So when I was denied, I started to seek legal counsel and construction slowed down. That's a simple response to that. Outside of that, I do believe that there's a possibility that since I've applied to be heard by you all, Metro Codes is pretty much like ignoring me right now, possibly. But I'm not a legal counsel. I'm just suspecting that could be possible. I've worked with Kimberly in Metro for years, and she won't even return an email right now, and I have no other explanation of that.
I also have one more question, actually. So, given your prefatory statements, you believe that this body has the legal authority to issue a declaratory relief or declaratory opinion stating that this particular provisions that you've cited are or are not valid, and then base our decision on that.
I fully believe, and there's plenty of case law to support that this board has the authority to interpret, apply the facts and interpret the law.
There's
as
plenty
we've
of authority
present
for that? This is a newly created board. Where would that authority be?
on every board and commission.
Gotcha.
The reason this board exists is
Right.
because of state law.
Of course.
There's plenty of case law on boards and commissions and how they conduct their business and what their role is.
Sure.
Clearly, there was an attempt to limit what you could consider by the Metro Council,
Right.
to kind of zoom it in here.
Right.
But you clearly have the authority to interpret.
Right.
And that's spelled out in everything I've looked at here. And so what we're asking for is to honor that 90-day period, which is in the code now. It's there. We want 90 days in which to finalize the permitting process so that he can receive the permit that he's applied for timely. He timely applied for the permit. It's not an issue that he didn't get it in time.
Right.
It's only an issue of the delay. And by the way, I hope you're aware of what Metro Codes just issued here 2 weeks ago regarding all the problems that they have had and third parties studying the procedural holdups that have occurred throughout because of the city's overwhelmed. They don't have enough people. They're overwhelmed and they can't get the job done. And this study and this report, which we put in the packet, obviously confirms that. And we're asking that he not be penalized by that.
Sure. But if we're talking about a 90-day period of validity beyond the 31st, that date would have run before today's date, correct?
Yep, this appeal would toll that. This appeal would toll that, meaning that 90-day would start from the date of this appeal, from the date of your decision. That's what we're asking.
Okay. Do we find that anywhere in the code, or is that just your particular reading of that provision?
That is pretty standard, that when you've got an appeal before a body that makes the ultimate decision, all the further actions are stayed. And we think that's kind of what's happened with the inspections and the review and everything. Everything's been put on hold until this board can make a decision. Once this board makes a decision, and we're asking for that 90-day period in which to finish out the permitting process.
Okay. Just for my edification, because I don't remember, I apologize. The application was filed the permit application was filed on what date?
Is it December 30th?
December 30th.
It's in here somewhere, but we think it's December 30th.
And when was the appeal?
That was
When was
December
the appeal
3rd.
filed?
I thought the
The appeal was
application was
filed
filed 12/21, didn't?
within the 60-day time frame in which to file an appeal.
Okay. But do you remember the
Did-
date? I'm
I
sorry,
had,
I probably
from
should
earlier
remember that.
remarks, I have that the application was filed 12/21/21. Am I incorrect on that? I believe one of you mentioned that. I wrote it down.
Well, let's see.
Somebody mentioned it.
And I apologize, I should have taken better notes.
Yes, ma'am, I had that in my case summary, and I am efforting to get the date that the appeal was filed.
Okay, thank you. Ron, please go ahead.
What's the status of the property now?
Oh, hold on one second. One, two,
Oh, down there, that's the right one. What's the status of the property now?
The property is ready for final inspection. So we're completely done. I mean, I don't have to do anything else other than get the 90 days and get the UNO from, and obviously stormwater has been held up, and we're just needing to get a decision done so we can move forward. And for the record, in the package that we sent over, there are pictures of a completed project.
Madam Chair, I've got the date of March 18 for when Mr. Kelly signed the application for interpretation against the zoning administrator. I believe that's the date that we filed it.
Okay.
any questions, Sean? Mr. McBroom, we have March 18th as the appeal date. Does that sound reasonable?
I have March 21st.
Okay.
Potato,
So
potato.
exactly 90 days, or nearly exactly 90 days.
Yeah. So your records indicate that you filed on March 18th. Our records indicate at Metro here that it was March 21st. Does that,
Mr. Kelly signed this on March 18.
Okay.
I don't know what day, I don't have that in front of me as to what day we actually submitted it.
okay.
Could have been the 21st.
So, Mr. Henry, I have one more question for you, then I'll leave you guys alone. So, in order to position, in order to make them as well positioned as possible, do you think it would have been a good idea for them to be ready for the approval at that 90-day mark? If your argument is that they should have been allowed that 90-day period, would it make sense for them to have been ready and say, all we need is the inspection?
He can explain what took place, but they have been ready. They have been ready. Metro has turned their attention to other inspections.
Right.
This one's on appeal. I can't explain what Metro has or hasn't done, except they haven't signed off on a final inspection, and I can't explain that.
Gotcha.
But to your point, I think I submit Mr. Kelly has been ready for months now to get this resolved, to get the final UNO, and there's been a drag, and clearly Metro understands that, you know, they've had problems with man hours, et cetera.
Gotcha. Sure. All right, that'll do it. My part
Any
of the
other
inquisition
questions?
is over.
Okay, very good. Gentlemen, thank you so much for your time. We're going to discuss this amongst ourselves. The public hearing is closed. If we have any further questions for you, we'll reopen the public hearing, but we won't have any further comments or exchanges unless we do, okay? Thank you.
So I've got a question for Mr. Hargis, if that's possible. So my question is, absent, you know, the 1633 was passed in 2019, and if we had done, let's say, nothing with 2021 913, the bill that established the UNO criteria, if that bill had not passed, and also if that Amendment 1 that was referenced had not been applied to that bill. The question I have for you, Mr. Hargis, is how would you have interpreted this application, no UNO issued, and the permit applied for on December 21st of 2021? How would you have interpreted that absent 913?
Sure. Let me get a copy of the bill back from Matt there. I gave it back to him midstream. I may answer those in reverse order.
That'll be fine, sir.
Sorry, Councilman Parker. Your questions were summarizing if, and kind of in reverse order, if Amendment 1 to Bill 913 had not occurred, what would be the result? The result for me would be that this gentleman's particular permit would have been issued. His application for a short-term rental permit predated December 31st. He was issued a construction permit prior, similar to the other gentleman's situation, the prior case. Both of these would be in similar position in that they made short-term application before December 31st. Their building permit was previously issued, so they would have been allowed to complete construction. Their filing of the application prior to December 31st would vest him in the ability to obtain that short-term rental permit. To the extent of Mr. Henry's comments, if for some reason that staffing situation there, that application drags beyond 90 days, I'm going to continue to honor that application, especially if the holdup's on our end. So we're not going to penalize an applicant for a delay on our side. So that's at least answering the question. Had Councilman Hager's bill not added the words "and final UNO letter for the building is issued on or before December 31st, you created a situation, or the council did, I don't mean you as a council member, but the council created a situation that permits were issued with the expectation I'm going to get a short-term rental permit, and then that expectation was cut off December 31st with this amendment. And I'm speaking from an administrator's perspective. That was my understanding of how it was going to occur, but for Amendment 1. Amendment 1, it puts a hard line on me that, I'm sorry, this building has to be completely finished by December 31st, or you don't get a permit. So that is the genesis of many of these appeals that you're going to see come up. As it relates to, what was the other council bill?
1633 was the initial RM. 2019-1633 was the initial RM phase out.
Yeah, the RM phase out for us would have been, I don't believe there was my understanding of that was a similar method of, so long as you had your applications in or you had a validly issued permit, that we'd honor that throughout. I think this amendment just added, I think, clarity to the permitting process. Mm-hmm. Once the bill said, hey, no more short-term rentals in RM, 913 created the process of, okay, if you get your application in by this day, you're vested in it. And then the amendment cut that off. So the effect of removing short-term rental from RM is the council's discretion to do so. We would just, any issued permits that had already previously been issued would be grandfathered under state law now. They'd be allowed to renew so long as ownership changes didn't occur or they didn't violate because remember the permits run with the ordinance at the time those permits are issued. They travel with that STR permit.
Okay, thank you. So I think that clarifies it for me. Thank you. So my I heard the argument that there was maybe so as 913 made its way through the council, a lot of us were initially very concerned about it, and that amendment was sort of the way of allaying those concerns and offering some clarity through the process. Right. So that got me comfortable with that particular legislation, and I can't speak to if there's a theory that it was written in a way that is not appropriate. I think that's a very technical matter, not one of intent or substance. So I think I'm not really prepared to accept that as grounds for saying that the zoning administrator erred here.
Yeah,
I agree with that.
Yeah, I don't think I respect Mr. Henry's argument very much, but I don't think our authority extends as far as he believes it does. I think this is likely a matter that the Chancery Court will get to sort out as to what we are and are not empowered to do, and what we can, the actions that we can take in granting relief. I don't find that the zoning administrator erred in this case either.
Yeah. I do agree that, the construction of that amendment may be a little bit awkward, and there's, cause to take issue with it. But I think the intent was, if I remember at the time, that we not have a bunch of placeholders for RMs or for non-owner occupied in these residentially zoned areas and cause a rush on, I stake my claim and I hosey all of these permits, when it was exactly what was the effort on behalf of council was to phase that out. And we were approaching that time for phase out. So I do agree. I'm completely flattered by the suggestion that we have more authority than we think we do. But I don't believe that the zoning administrator erred in this case. And I'm comfortable that that is really the only question before us today. And there are other remedies, yes, beyond us.
We certainly are not the last, we're certainly not
So
the last word.
I feel comfortable with my take on that. Ron, what do you think?
Well, I agree with your take. I think, but I think we're not the court of last resort, as,
No.
as the gentleman suggested here.
Yeah. Okay. Shall we have a motion?
I move that the zoning administrator did not err in no relief, and wow, I moved that I could actually talk for a second. I move that that the zoning administrator did not err in making its determination in this matter, and that no relief will be granted.
I second. Can we see a show of hands? Okay. Thank you so much, Mr. Henry, Mr. Kelly, for your time today. We appreciate it.
The next case before the board is case 2022-25 for 6121A Neighborly Avenue. Is the appellant present? Is there opposition present? Is there opposition present to this case 6121A Neighborly Avenue? Seeing none. This is a denial of a short-term rental permit for an HPR with a divided ownership. This is an R6 zone district. HPR, horizontal property regime, is a zoning policy which essentially allows two houses to be built on one piece of land that was previously zoned for just one house. This HPR has its own set of legal requirements and governing rules. Most have bylaws that disclose how the regime will be governed, typically resulting in the creation of a homeowners association. It must be legally registered. Whoever buys an HPR owns only the house and the land beneath the house. The rest of the land is considered common area and is maintained by the HOA. This appeal is governed by 2020-187, and the decision of the board is whether or not the zoning administrator erred in denial of the permit. 6-28.030 short-term rental property permit. Section C, to qualify for short-term rental property permit, owner-occupied permit, the owner of the property shall permanently reside in the STRP, or for conforming uses in single-family and 1- and 2-family zone districts, the owner shall permanently reside in a residential unit on the same lot. The owner of the property, 1, must be a natural person or persons. 2, may not be a limited liability entity, including without limitation a corporation or a limited liability company. And 3, may not be an unincorporated entity, including without limitation a partnership, joint venture, or trust. Only 1 permit shall be issued per lot in a single family and 2-family zoning district. Ownership of 2-family dwellings. The property ownership of the 2-family units cannot be divided. The 2-family units shall be owned by the same person, and one of the 2 units shall be the primary residence of the owner. Prior to the issuance of the permit, an instrument shall be prepared and recorded with the registrar's office, covenanting that the 2-family dwelling may only be used under the conditions listed above as long as the STRP owner-occupied permit is valid. Notwithstanding any provision herein to the contrary, the residential dwelling created by or contained within the horizontal property regime pursuant to Tennessee Code annotated 66-27-101 and following shall not be limited or otherwise restricted by subsections D or E or this section if a permit was issued on or before July 1st, 2019. March 29th, 2022, owner-occupied STRP permit application was submitted. On initial review the application, it appeared that this was a 4-unit multifamily development. It had this appearance because the 4 units were developed simultaneously by the same owner-developer as a single development. However, upon closer examination, it was realized that this is 2 adjacent HPRs. Therefore, this being an R6 zone district, it is governed by the highlighted portion that I read previously of the ordinance above. The ownership of the HPR is divided as 6121B Neighborly Avenue is owned by persons other than the appellants. When Program Manager Robert Osborne completed the review of the permit application, he emailed the appellants that the permit could not be issued because the STRP ordinance prohibited it.
Okay. I'm sorry, our papers are a little sifting is required to catch up to where you are. I don't have that second page. I'm sure I do. Does anyone have questions for staff while I frantically look through my papers?
Pressure remains on, I'm afraid.
No? All right. No questions? All right. Do you have that second page? Or can we scroll down to that second page, please? I don't seem to have that in my packet. I'm just talking back. About the review? All right, it's fine. Okay. Thank you. Okay, no one has any questions for staff or Metro before we get started? Hi, folks. If you would be so kind as to open the microphone. We don't have any opposition to this case, do we?
Did not see any, no, ma'am.
Okay. When you speak, you're going to open the mic. You're going to state your name for the record and your address. And we are going to have a timekeeper. You won't have to save time for rebuttal since there doesn't seem to be anyone here to speak in opposition to your case. But go right ahead, tell us your name and your situation.
My name is Jessica Shiflett. I reside at 6121A Neighborly Avenue, Nashville, Tennessee. We first just want to thank you all for the opportunity to appeal our denial of our short-term rental permit. We were denied our short-term rental permit due to the following quote from our denial email. I apologize. When I first reviewed this property, I thought it was 1 lot with 4 dwellings, but it is 2 lots with 2 dwellings each, and this causes your property to not be eligible. As stated in the Declaration of Covenants, Conditions, and Restrictions for Neighborly Village, it states that each owner is entitled to 1/4 ownership in the common elements. And this is why we believe we are indeed 1 lot with 4 dwellings and should be allowed to receive a short-term rental permit because our lot has divided the common elements into 1/4 and not 1/2. Read in the legal description of Neighborly Village, all 4 houses are on lot 16 in the Cowden subdivision. We believe, according to the documents provided, which I have all these, the original developers of Neighborly Village were granted 2 addresses on the said lot 16. Even in the post-development documentation slash plans that we received from our builder, all 4 properties continue to remain on the same lot of the John B. Cowden 3rd subdivision and continue to be referred to as lot 16 for all 4 dwellings. In addition to the parcel, the deeds clearly show that the plot of land has 4 homes and not 2, as it was deeded from the same developer. Our deed makes reference to a 4-instrument NOS, including / listing all 3 of other properties on our singular lot. We understand that the nature of the HPR restrictions on short-term rental was to prevent the disturbance of the peace with surrounding neighbors and attached properties on singular lots with only 2 dwellings. We do not believe the nature of the HPR law applies to our specific situation due to the above, as well as we have written and verbal agreements from each owner in Neighborly Village that we can provide, as well as surrounding neighbors stating they are in support of us obtaining a short-term rental permit. All this goes to say this is why we believe the zoning administrator erred in denying our short-term rental, as we are one lot with 4 houses, which was even Mr. Osborne's initial interpretation.
Thank you. So if I'm hearing you correctly, the HPR structures this as more like 4 units with common ownership of the lot. But the permit was denied because it was interpreted that this is a 2-family lot where the ownership cannot be divided under the rules. Okay, this is interesting. This is an interesting case. Thank y'all for bringing it to us. I'll let some other discussion happen now that I've got a picture what's going on.
I do have a question, and I'll put it to you guys, I'll put it to the board, I'll put it to Metro, whoever wants to weigh in on this. I understand that your CCR says, no, we're going to be one way, but does what you put in a CCR that you're allowed to write yourself dictate what it is, dictate the structure?
Are you asking about the 2 HPRs being side by side?
Well, appellants stating that, as you see in the CCR, we've all agreed to fractional ownership, basically, right? Is that up to the author of a CCR to decide?
The actual zoning of the property will dictate what is allowed there, not the CCR. The CCR can make prohibitions, but it cannot extend what is allowed under the zoning code. And if you'll notice on page 2 of your packet that my summary, the 2 properties, the dotted line that is between the 2 properties there is the separation of the lot as interpreted by the zoning administrator. Therefore, it is 2 HPRs side by side. The confusion came in because it was developed all at one time by one developer.
Mm-hmm.
So my sort of read on that is that yes, the what can be built there and the allowed uses are determined by the land use table.
Mm-hmm.
And even though you've adjoined 2 HPRs here in a some kind of legal arrangement of common ownership, I don't think that supersedes land use as prescribed in the land use table, but not a lawyer.
Well, the code actually should drive the creation of the document, not the, because otherwise you're taking a risk that you might have entered into an agreement that you can't really make effective because of restrictions in the code.
Yeah.
So it's a risk that maybe some want to take, but it's not always going to inure to your benefit, certainly.
Well, we just, yes, sir.
If I might add, again, just to reiterate, the agreement cannot expand the use of the property beyond what the zoning code allows.
Right.
It can further limit it.
Yep.
Right. And there's no dispute that you all only own one of the properties on this tract, correct? Okay.
Yes, yeah, just one.
Do we have any other questions for the appellants? Or are we ready to close the public hearing?
I don't really have any questions.
No, I think we should close the public hearing. I don't think you used your allotted time, so, right, please, go right ahead.
The dotted line that we've been aware is the shared common driveway between all of Neighborly Village.
it may represent to you the driveway, but it seems like there's a intended use.
There is a shared easement there for the
Yeah.
driveway that happens to be on top of the dividing line, but that is just done by agreement. It doesn't affect the fact that the line exists.
Yeah, okay.
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 Thomas Shiflett, 6121A. So can you have commonly shared areas between two HPRs, two different HPRs, is my question. Is because this was what's going on. If this is two HPRs, where you have commonly shared area between the two.
So I think that's like a legal agreement between the parties to the HPR. It doesn't change the underlying zoning necessarily and what's permitted under the code, unfortunately, in your case, I think.
So was this correctly awarded an HPR in the first place?
So I can tell you from my experience, like I'll have people file an HPR on a single family lot because they want to try to build 2 units and, they can go file it with the Register of Deeds. That doesn't mean that when codes goes to interpret whether they can build 2 units, that codes is going to permit them to build 2 units because it's still a single family lot. So the HPR, as Mr. McBroom stated, it can restrict elements, but it cannot add things to a property that are not in the code, unfortunately.
Mm-hmm.
Although as I said, this is an interesting one, and I do appreciate y'all bringing it to us.
Because the initial house that was on our lot was one house on the entire neighborly village. It crossed the dotted line. The original house sat on the cross dotted line.
Mm-hmm.
That's why we believe that it was never truly separated into 2 separate lots, because even in the post-development, we both sit on lot 16.
But I think what's governing here is the zoning district within which your property is located, which is the R6 zoning district, which is a 1 and 2 family zoning district.
So it wouldn't make a difference that he initially thought it was 1 lot with 4 dwellings, and that's what we believe that it is.
Well,
It's medium density residential, so that's what it's limited to.
it's still a 2-family zoning, even though they built 4 together and established an HPR that has 4 units in it. That doesn't make it a multifamily property. It's going to be two family properties is my understanding of the interpretation. But
I don't disagree with anything you said.
I'm sorry.
I don't have the front page to this one. What is our discretion level on this one?
It's, I think we're determining whether the zoning administrator erred in not granting the permit.
Yes, that's correct.
Okay.
Okay.
So
We should close the public hearing, unless you have any other questions, Ron? Okay, we're good. We're going to consider the public hearing closed. We're going to discuss it amongst ourselves. If we have any further questions, we'll reopen it. I think we've kind of had our discussion, but yeah, I mean, it is tricky. There's no doubt. And I can see where a layperson, we're all kind of lay people, would look at that and say, oh.
Right.
I get contacted frequently by folks who, they want to be able to build a daydo behind their HPR. They want to get a short-term rental permit. Some of these are built in a way where there's 2 separate fences for each backyard, and they look the same as the 25-foot lot, single-family homes in the neighborhood, but legally, they are 2-family homes, and it's caused a good deal of confusion. But the law as it stands today, I don't think it was interpreted incorrectly by the zoning administrator here.
I concur.
Yep. I concur. Do we have a motion?
I'll move that the zoning administrator did not err in this case.
Second. So we move that the zoning administrator did not err, and we will not be offering any relief in this case. Can I see a show of hands? Okay, very good. Thanks so much for coming in today,
Thank y'all for
folks.
coming
We
down.
really appreciate your time. All right.
Let's shuffle our papers now.
I know, honestly.
Next case before the board will be case 2022-27, 911B and C, 19th Avenue North. This will be governed by BL 2020-187, effective date 7/10/2020. The board's decision is whether or not the zoning administrator erred in canceling the permits due to ownership change. The reason is that as of January 1st, 2022, non-owner-occupied STRP permits are no longer available in the RM20 zone districts. The State of Tennessee Code Annotated Public Chapter number 972, House Bill number 1020, Section 13-7-603, subsection A, except as otherwise provided in subsection B, an ordinance, resolution, or regulation, rule, or other requirement for any type that prohibits, effectively prohibits, or otherwise regulates the use of a property as a short-term rental unit shall not apply to a property if the property is being used as a short-term rental unit by the owner of the property prior to the enactment of an ordinance, resolution, regulation, rule, or other requirement of the local governing body. The ordinance, resolution, regulation, rule, or other requirement in effect at the time that the property began being used as a short-term rental unit is the law that governs the use of the property as a short-term rental unit until the property is sold, transferred, ceases being used as a short-term rental unit for a period of 30 continuous months. This differentiates ownership changes from expired permits. The ownership change cancels or voids the permit, at which point it is no longer grandfathered under the Metro STRP ordinance in effect at the time the permit was issued. Expired permits where the STRP operations have not ceased for 30 continuous months are grandfathered under the Metro ordinance in effect at the same time the permit was issued. On March 19th of 2019, not owner-occupied permit application was initiated. April 26th of 2019, the permits were issued. On May 17th of 2019, Airbnb website ads posted Unit B and Unit C. On May 24th, 2019, VRBO website posted for Unit B, and on January 20th, 2020, VRBO website posted for Unit C. March 4th, 2020, permits renewed. March 17th, 2021, permits again renewed. December 28th of 2021, 911B, 19th Avenue North had an ownership change by quitclaim deed from DY Properties 2 LLC to Charles Properties LLC. 911C 19th Avenue North had an ownership change by quitclaim deed from DY Properties 2 LLC to Emery Properties LLC. By law, these constitute changes of ownership. Metro Ordinance 17.04.060.E.4.K, an STRP permit shall not be transferred or assigned to another individual, person, entity, or address, nor shall the permit authorize any person other than the person named therein to operate the short-term rental permit on the property. The Metro Nashville Government Law Department, after consulting with the State of Tennessee Law Department, opines that any change in ownership of a property with an STRP permit results in the cancellation of the STRP permit when the ownership change is completed without exception. 911B 19th Avenue North had 4 documented stays. There were 3 on Airbnb and in January, February, and March, and 1 on VRBO in March. C 19th Avenue North had 6 documented stays after the sale, and that was on Airbnb March, 1 January. VRBO had 2 March, 1 February, 1 January. On April 15th of 2022, all website advertisements were removed. There was a total of 4 documented stays after the change of ownership. On December 28, 2021, at 911B 19th Avenue North and 911C 19th Avenue North had a total of 6. There were no documented complaints on the property in either the Metro Hub or the host hotline.
Can I just inquire very quickly, was this a matter of the cancellation being sent to the appellant?
Yeah.
How did we end up here today? I mean, I understand that it was canceled due to a change in ownership, but was there a stop work order or something?
My understanding is that the permits were not allowed to be renewed.
Okay. So the renewal was denied due to the fact that the permit had been previously canceled?
That's the best that I can determine. There was no documentation of a letter being created or sent as far as cancellation is concerned.
Okay, very good. Anybody else have questions for staff?
I apologize. Is there opposition to this case? 911 B and C, 19th Avenue North? Seeing none. 5 minutes.
Great. Very good. If you could share your name and address for the record and tell us about your situation.
Sure, thank you. My name is Grover Collins of Collins Legal. That's 414 Union Street, Suite 1110, Nashville, Tennessee, 37219. I have Mr. Duran Jenkins next to me, who owns the aforementioned properties. It's a pleasure to be before you today. I would like to stress that if there were a theme to this case, it would be this is the result of some bad legal advice. Fortunately, it wasn't my own legal advice, but that's why we are here today. I also want to stress the point that as we're here, Mr. Jenkins owns and operates several of these properties in the area. They were all in LLCs before the transfer. Single member LLCs. He transferred them pursuant to this plan for investment purposes and estate planning purposes. He transferred them into LLCs. Again, single member LLCs, which he owned, and still, once he found out that there was a problem, transferred them right back into where they were. So that's a synopsis. And to answer Chairman Ryan's question, he renewed these permits and wasn't alerted that there was a problem until he went to renew it for 2022, and there are no documented stays after that notice that he received, and I've put that in the documentation. He received that notice for B on or about April 13th, and for C on or about April 27th. That's on page 2 in paragraph 2 and 3. You'll see that as we go through there. It's important to note that when you apply for a permit renewal, they go ahead and check to see if there's been any ownership changes. This isn't something that Metro was alerted to or there were complaints or anything like that, and then they found out. So to briefly get into it, I know we only have 5 minutes here, but I do want to say that this is somewhat nuanced as it relates to the state law. So we're going to spend a little bit of time talking about what is and what isn't a transfer as it relates to the state law. So in 2018, in May 17th of 2018, that would be after the last regulation of 608 so BL 2017-608 would have been the effective when he got his permits. Then the state law came down. Then later after that would be the BL 2020-187, which I would submit that 608 would be the applicable statute here pursuant to the statute. However, in 603, this is Tennessee Code Annotated 13-7-603, until the property is sold, transferred, or ceases to be a short-term rental. Okay, so this property was not sold. These were quitclaim deeds for zero consideration. There was no transfer tax or anything like that. So this is clearly not a sale. It's from one single member entity that he owned to another single member entity that he owned by a quitclaim deed. So the operative word here is transfer. We've gone into very large depth in the materials that we submitted to you. Bottom line is, when the state went to amend the statute for 603 and 604 and the definitions under 602, they screwed up. What they wanted to do was they wanted to say that if you're going to a trust or there's a divorce or anything like that, there's no transfer tax, we're not going to say that's a transfer. But what they did is they said those are the only times it is a transfer. So what we've got now is we've got a completely screwed up state code right now that we've tried to fix, and we didn't get there last time, but irrespective, transferred is the operative word. So we submit that anything that's related to a short-term rental, the state has preempted and said this is what the law is going to be. And they have set the definitions as to what the transferred means. And what they have said that means if it's after 2018, which this is, May 17, 2019, and it meets B, and B references the tax recordation statutes. So it's all the recording statutes for exemptions for when you don't pay the real estate transfer tax, okay? Everything else is not a transfer. So we would submit to you that because he put this into the name of another LLC, this was not a transfer because it doesn't fit the statutory definition that is the law of the state as it relates to short-term rentals for what is a transfer. Therefore, if it wasn't a transfer and it wasn't a sale, then all he has to do is simply change the name on the permit, if at all, if he even has to do that. Furthermore, because he has already put it back into the LLC name that it was originally on, and we don't have a transfer either way, because we don't have a recordation tax on the quitclaim deeds, there should be no reason with him simply being able to reinstitute the permit as he had and allow him to renew that. And I now have only about 10 seconds left, so I'm going to stop there, but I'm happy to take as many questions as you have on that.
Okay. Who has questions? I will start with my question, which is, you were the sole member of the previous LLC that owned the two, and I'm so sorry, introduce yourself and give your address before you answer my question, which is, you were the sole member of that trust that owned the properties previously, and you're the sole member of the two trusts that own the properties now, or the LLCs that own the property now.
Well, my name is Duran Jenkins. I live at 1433 15th Avenue South. But yes, to answer your question, unfortunately, I was given some advice by an attorney that doesn't specialize in short-term rental. And now being into this situation, you need to go to school to be a short-term rental attorney, from what I've learned. So, I mean, literally, it's still me. I was doing it from advice from an attorney, literally to protect myself liability-wise and tax purpose-wise. So it wasn't like I didn't sell it, nothing changed. I'm still the same person, the same single member. I mean, you know, if it's kind of like common sense. I know that, you know, he's an attorney and he speaks like an attorney does, but in reality, you know, I consulted an attorney. He said that was, you know, would be a good thing or smart thing for me to do. It was wrong. And for me, I mean, I've owned these properties. I actually built these properties. I've owned them for 13 years. I have, you know, another 13 properties on this street. I've been in Nashville for 20 years. So this isn't about like me trying to sell it to somebody or something like that. Like this is my retirement. This is, you know, I was on this street when Airbnbs didn't exist. Like it was just, nobody would even come on the street, to be quite honest with you. So to answer your question, I'm sorry I was a little long-winded, but to answer your question, I am still the same person as all of them.
Okay, so you were DY Properties and
Yes,
you are Charles Properties. You were DY
Charles is my middle name. My name is Duran Charles Jenkins.
Okay, and Imori is, that is you. You're
it's
the
my daughter's
sole-
middle name.
Okay.
Yeah, but yes, to answer your question.
I, as the legislator of the group, I am curious about is it Mr. Grover or Mr. Collins?
I'll respond to either, but I would go by Mr. Collins.
Okay, Mr. Collins. So, you know, you said that the state law sort of was worded peculiarly.
Terribly.
In that it defines these things that we all might sort of just look on faith, say, well, that's not true. You got a divorce, you're doing estate planning, those kind of things. But then you also said that these transfers don't meet the statutory requirements of a transfer. So, I mean, it kind of sounds like maybe it's not even necessary to amend that. I mean, how is it, like, if these things don't, as you've argued, if they don't constitute transfers to begin with, is there really any issue with how the state law is worded?
There's unbelievably an issue with the way the state law is worded, and I'm going to try to parse what you asked with a direct as direct an answer as I can give you, but I'll tell you this. And please understand that I have talked to the senators who introduced the bill. I have read the legislative history. I was there at half of the meetings. They specifically set out, there was a problem that had happened in the BZA, and it had been taken to court several times, where if I were married and got a divorce and I quit claimed that out of my name and left my significant other on the deed, was that a transfer that would be a transfer under the short-term rental? The state legislature did not want that to be a transfer. They also did not want it to be a transfer if you put it into a trust. They did not want it to be a transfer if there was some other intricacy like that, and I've enumerated them in the paperwork, and there's three general exceptions they sought to exclude as a transfer. Well, what they did was they said, this is the only thing that is a transfer. So when they did that, they opened the door that said, if these are the only things that are a transfer, and we have it defined in 602, 13-7-602 is the definition section of our short-term rental act. So these are what these things mean. In that definition in 602, it says, if it happened after May 17th of 2018 and, semicolon, and it applies under these specific tax recordations, then this is a transfer. Meaning everything else, specificity is over the general, right? So if we're saying this is what it is, then everything else is not a transfer. And then we only use words in the statute itself and the rest of the act in 603 and 604. In fact, in 604, it says, nothing in this subsection extinguishes a provider's right to the continued use of a short-term rental as set out in 13-7-603 unless the property is sold, transferred, or ceases to be used as a short-term rental. So because they had defined the word transferred, that's why they use it throughout the act. Mm-hmm. So the legislature has got to fix it. And I'll just be very frank with you, we had it teed up for them to change it this legislative session. And I don't know, you clearly know how the sausage is made back there, so you know what happens. There was an amendment that happened or something, you're on the 10-yard line and the ball gets dropped. So it didn't go all the way. So because of that, we still have this definition that's problematic within our current state law. And I'm going to tell you the unfortunate thing about it, and the reason it absolutely has to be changed, is I have had clients who have tried to put it into a trust or tried to put it into, they had a divorce situation or something like that, and they've been excluded because it was literally the definition of a transfer. And so not only does it have to be changed, it's hurting the exact people that it was meant to help. But in the meantime, we have to follow the law as it's situated in the state of Tennessee right now, or they're not going to change anything. And right now, the definition says if it's not these three situations, it's not a transfer. And if it's not a transfer, I take issue with the word ownership change, because that's not relevant, because that's not a definition within the state framework.
Okay, thank you for just one more follow-up question. Thank you for that information. And so did I hear correctly that the properties have been moved back to the original LLC? So the two properties which were put into individual LLCs are now back with the single LLC that they had been in previously?
Yes, sir.
Okay, thank you.
Mr. Collins, I think you eloquently laid out, issues with the language and why we're in the position that we're in today, that we even have to hear this case. But is it, in order for your argument to be successful, you also have to take the position that we somehow have authority to correct the legislature's error. Is that what you're saying?
No, not at all. I'm saying because of the error, you have the authority to say that this interpretation is that it's not a transfer.
But until that error becomes codified in the form of a fix, it says this is now how the definition reads.
It is currently codified as an error.
Right. But that is your read. That is your read on it. There has not been remedial legislation that says, "Hey, transfer now means this," which clearly takes this transaction that happened out of that category.
I guess you're asking me to argue a negative. I would say so. I guess right now, the plain reading of the statute is these are the only things that are transfers.
Right.
So I'm asking this board to agree that because this wasn't one of those things, then it wasn't a transfer. Because the state has defined, these are the only three things that it can be.
Gotcha.
So because this isn't one of those things, it's not a transfer, and therefore the interpretation of the zoning administrator was incorrect.
Okay, I got you. So you're saying the language already says what it should say then? With
For
regard
the
to-
purposes of this argument, yes. It doesn't say what, the legislatures didn't get it the way they wanted to get it, but for the purposes of my argument, it reads the way I want it to read for,
Okay, so it's.
as I'm sitting in front of you.
It's a mistake, but it's favorable to you in this case.
In this case, yes.
Okay, gotcha. Do we actually have, because you were mentioning in the materials, there's a write-up on this. Either I'm stupid or, which is entirely possible.
You can have my copy.
No, no.
I don't have it. Yeah, of course. Thank you so much. And I apologize. Yeah, I don't have this. Do you all have this?
What is that? Case?
It's pretty much brief.
Yeah, we submitted it, so it should,
Oh, you submitted a formal, okay.
Yeah.
I don't have this.
believe I have
I
that.
don't have it in paper in front of me. I would like a copy of this.
Because you were sort of giving us the analysis on the language. I'm like, wow, I'd really love
Yeah.
to see that in writing. And, all right.
Have that electronically at
and
least.
and I'm happy to email it if y'all wanted me to. I don't want to blast your emails out there, but I can.
Yeah, that wouldn't be bad because I really do think the discussion is going to benefit from being able to actually read your, petition.
I think too, we've had, and this is, I know we still have the public hearing open, but amongst those of us that are here today, we've had this kind of issue come up a few times. And we've talked about what the local ordinance, what the goal of the local ordinance was. And it wasn't to go, it was to avoid having properties that were sold to other parties as short-term rentals, so that you wouldn't have neighbors who were, kind of, I keep coming to the word stuck, and I don't mean it to sound as censorious as that, but so that you wouldn't have neighborhoods and neighbors and properties that were permanently deemed STRs for all eternity. And that was kind of the goal of the local ordinance, having an issue with ownership change, canceling a permit. So the problem is, in the past, we have offered relief to those who were given a waiting period before they were to reapply. And in this case, this is a gentleman who is now not permitted to reapply because it was a non-owner occupied and they're no longer permitted in that area. So I think it's not just the semantics about that question, but if we are to act on this, it would be something along the lines of saying that the cancellation we would have to deem it in error, or there is no relief that we could offer, right? Because we can't undo the rules that went into place as of January 1 of this year. Right? Mike's looking at me very concerned. Do I make sense? There's not a simple remedy.
Madam Chair, can I ask a question? from a zoning administrator's perspective, and I guess I'll ask this of the appellant in front of us. If I as administrator were asking you to postpone this case until I had more clarity from Metro Legal, let's say one meeting, next meeting, and I'll ask it of the appellant too, because as of now, he's not renting, so status quo for him. Is that something you're agreeable to and with this board? Because I think Mr. Collins raises an interesting question about transfer. It's not an ownership change. And I'm sitting here hearing his argument and agreeing with him. But I really would, which would say, well, I shouldn't have revoked his permit. I agree. I would like, yeah, of course you agree. I would like to talk
This is going great for you.
I would like to talk to our legal counsel about this, because if his particular situation is one in which we're supposed to apply the state law to the local law, and it's not a transfer under state law, then ownership didn't change, then his permit should be in effect.
Because I would be amenable to that because of the sort of technical argument that's been made. I mean, I think there's some compelling stuff here outside of that, but I mean, I would be amenable to getting further legal clarification specifically to the detailed argument that was made.
So I think there are definitely some depths we need to plumb here.
I would go beyond amenable and say I'd be delighted to defer
We're
this.
happy to defer. And along those same lines, if there's any questions that have been arisen through this discussion that we've had today, specifically of the board, I would love to have the opportunity to give you a response to those questions so that you have the full response that you would need in the form that, as I've put forth before you today. So if anything like that is needed or wanted, let me know and I'm happy to do the work.
So I think just from sitting on boards, public boards, we might want to direct those questions through staff.
Yeah, I think they're going to have
sure.
to be, because we don't want to run afoul of public or.
Sure, yes. Let's not. But
Need we make a motion to defer?
yes.
Okay.
I believe we need a motion to defer, and I will move to defer this case one meeting. I think that's all we need, yes. Seconded.
Okay. Show of hands?
I'm sorry, just as a point of clarification for the record's sake, has the public meeting closed?
It has not.
Okay, so we were deferring, and then if there are new members, then we start all over? Is that?
No, they can watch today's proceedings and become eligible to participate. We would have to poll them at the next meeting, whether do they wish to participate.
Just wanted that on the record.
Yep.
Well done, because I had not thought of that. So can I see a show of hands that we're deferring to the next meeting? Very good. Thank you very much, gentlemen. We appreciate your time.
Okay, I think we've got one more.
One more case.
I don't think it's the same case.
It's not.
It's not.
It's not.
Next case before the board is 2022-28, 1000A West Trinity Lane. Permit denied for advertising and operating before obtaining a short-term rental permit. This is governed by 2020-187. The decision of the board is whether or not the zoning administrator erred in the denial of the permit. The previous owner, Up Partnership GP, had a not owner-occupied STRP permit issued January 6, 2021. Previous owner posted 2 website advertisements on July 25th of 2021, Airbnb and VRBO. January 13th of 2022, Up Partnership GP sold the property to Toshimi and Asher Brustein and Phuong Tao Do and spouse Michael Nguyen. This canceled the former owner's STRP permit on February 11th of 2022. 1000A West Trinity Lane had an ownership change by quitclaim deed from Tashomi and Asher Brustein and Fong Tao Do and spouse Michael Nguyen to Renolo LLC. March 18th of 2022, a not owner-occupied STRP permit application was initiated. On March 21st, 2022, the Airbnb advertisement was removed. On March 22nd of 2022, the Administrative Services Officer Madison Neal reviewed the permit application and found that the ownership change had occurred on January 13th and that there was a documented stay in March of 2022, which is below. March 22nd of 2022, Administrative Officer Madison Neal emailed the appellant and informed them that the permit was denied for advertising and operating without a permit. On April 14th of 2022, the short-term rental appeal was initiated, and on May 6th of 2022, as of this date, the VRBO advertisement remains posted, but I was unable to book reservations on the calendar.
Great. Any questions for staff before we hear from the appellant? No? Okay, very good. So, Mr. Asher, is that correct?
Mr. Wetzel.
Oh, sorry. If you could tell us your name and your address for the record, and then tell us about the situation.
Kyle Wetzel, 412 Bugby Court, West Columbia, South Carolina.
Okay.
So this was a unique case for us as the operator, just based on the timeline of events. We were not made aware that our prior owner to the appellant was selling his unit and in fact sold the appellant on our services as well. I received an email on 3/17 with a notarized affidavit from the appellant and immediately went into panic mode as I knew what this meant. We put a 31 plus night minimum on all listings to prevent bookings in between existing reservations and initiated relocation on all future bookings until the new permit was acquired. We had a guest check in on 3/16 the day prior, and unfortunately we were unable to relocate that guest from the unit. The application was submitted on 3/22. I know the case record says 3/18, but I do have a screenshot that it was submitted on 3/22. That day, I received email notification from Madison Neal that there was evidence of a documented stay, and due to the nature of how this all transpired, decided to make the appeal to attempt to give perspective on relief for this situation. As I said at the beginning, this was a unique case for us as the operator. We have had no complaints or permit issues that have tied up Metro's resources and time prior to this. We utilize noise monitoring and camera systems to be proactive and neighborly. We have assisted Metro during criminal cases, even when footage capture does not pertain to our guests or our units. We strive to remain in good standing with the law and operate with the duty of care towards our neighbors, guests, and owners. I appreciate your consideration and would ask for relief based on the timeline mentioned. And I will say, if there is a VRBO listing posted, I know the host compliance that was pulled did show that we were honoring only a 31 plus night. So if there is that would be news to me, but I would assume it's a 31 plus night minimum on that VRBO listing.
Great. Thank you for your brevity. It's greatly appreciated. Any questions for the appellant? Or for Metro, for that matter? So I'll jump in. So you're owner. I mean, you're an operator, not an owner.
Yes.
And you've never had a ownership interest in this property. You were just the operator of the previous.
We were the operator for the existing owner, and then we were unaware of this process happening, and then received that affidavit, and we were just a little surprised and tried to do everything. And like I said, that guest checked in the day before I received that affidavit, and we were unable to relocate that guest.
Right. Okay. And can I ask you how many other properties you manage in Nashville?
Close to 70 at the moment. This is the first instance to where an ownership change, which the new owner assumed this is the first instance that we've had like this.
So there never was an opportunity to take the ad down because you probably managed the ad.
Yes, correct.
And you had no idea they'd sold the property.
Corporate office managed, as soon as we received that, notified the team to put a 31-night minimum on, so that way it essentially blocks off all of the gaps in between future reservations, and then to initiate relocating based on first in, first out. So like the following weekend, get that, go start relocating process, to obviously, knowing this permitting process, the next weekend's guests wouldn't be able to have legally stayed there, so we just started attempting to relocate.
Got it. And is Goodnight Stays your company?
I was general manager for it. I don't own the company.
Okay, great. Any other questions? Nope. Okay.
None for me.
Well, we're going to close the public hearing and discuss this quickly amongst ourselves.
Well, I mean, this, it seems like a sale. I mean, I don't think there's gray area
No.
about a transfer.
No,
100% a sale.
here,
Yeah, definitely a sale.
And Bill 187 did sort of remove our discretion in cases like this. This is one where prior to 187, it might come before us and we could say, oh, well, you did all the right things, you followed all the rules, so we'll offer some reduction in your wait time.
Yeah.
And,
I don't.
and to be candid, I wish we could, because I feel like this is a de minimis, sort of step over the line if there was one. So I have a little heartburn over.
But this is governed by 187, which says that we don't really have any discretion except for to say, was there an error made? And
Right.
there wasn't an error made.
Yeah.
Not by zoning, by the previous owners.
Right.
And by the current owners for not alerting the team, but
Right.
yeah, it wasn't an error on Metro's part. Agreed?
I don't like it, but I agree.
Shall we have a motion?
I'll move that the zoning administrator did not err in cancellation of this permit and in not issuing this one.
It's like
Can I
Gretchen's
see a
second.
show of hands on the motion?
I'm just going to raise it halfway. Minimum agreement.
Unfortunately, we're just not able to offer any relief, although we are sympathetic to the situation. We really are. So thank you so much for your time today.
Thank you. Ron.
Ron, second. Okay, so that concludes today's short-term rental appeals board hearing.
Stand adjourned.
We stand adjourned. Biggest crowd we've ever had.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.